Please don't let me do it. Don't put me in residential. Don't. And I listened. We put you on probation. A month and a half later, you pick up a felony DWI. So all this acting.
I heard that.
Okay, Dustin.
So, one issue, as far as the GPS monitor and all that, they gave them a new device just now. They said it was a charging issue. They plugged it in, it would charge for 10 minutes, stop charging. He has a brand new one they just put on this morning. Now, the drug test
violation issue, that he's out at 3 a.m.
Well, no, it's not that he's out, is that's when it reconnected. So but they gave him a brand new device. So and they're saying there was an issue where they changed the device out and there's not a tamper on it. It just said it was not receiving. It didn't say it was that he was out and about. It said it wasn't receiving, and they started receiving again. That's at least the report that I saw. It's not like they were tracking him other places. But as far as resolution of the case, I did talk to him, and he is interested in participating in DWI court. And because we talked about that last week, and I have visited with him on that this morning.
Says here on 3/11/24, GPS device generated a failed to enter alert at 10:15 p.m. At 11:46 through 3:02, GPS device was in no GPS, no cell status and was unable to be monitored during the time frame. Client arrived home at 3:01 a.m. on 3/12.
So that's not when it arrived home. That's when it started charging again. Because it's not a geolocate. I mean, as far as I'm understanding, it's a GPS shows where he is. Not.
I'm going to be honest, Your Honor. That would be a question for pre-trial.
Oh no, I'm sorry. It's pointed to the client, not to you.
Okay. I was like,
Saying out and that he's out in the middle of the night.
I don't think they're saying that. What they're saying is that it's received a no signal.
Client arrived home at 3:01 a.m. on 3/12.
Where was he before that?
Huh?
They don't know where he was before that. He was at home. He just wasn't charging.
You have.
That's the way I'm reading it.
Do you have? You have the idea of where he is?
I don't see any notes from the case manager, and then at 10:05, I see on the report, it's showing that he's not at his home location. So I think that would be the fail to enter. And then there was the portable violations as well that were added. But again, from what we discussed earlier, I don't, necessarily have to go forward.
Portable the violation in what respect?
They sent an email yesterday from the supervisor that was here earlier, stating that there were additional.
Did Anthony send that?
No, it'll be from Cody Pittman.
Okay, see.
This specific one is from Luis Galvan.
So I also have here, client was also instructed to obtain a portable alcohol testing device, comply with all testing protocols, refrain from alcohol consumption, and comply with all routine equipment service. The defendant failed to provide breath samples, scheduled times, resulting in 13 skips from 2/7/25 to 3/17 of 25. So he's still skipping tests. Come up, Mr. Jones. I just don't get it. I truly don't. It's over and over and over. You are still skipping tests. And I don't know what it is and what I need to do to get you to comply with bond conditions. You're still skipping tests. I mean, I have no other choice. I now have to revoke your bond again.
All right, well, then let's do a plea then.
Huh?
Let's plea it.
I agree with, and I'm okay, but I'm going to tell you now that I want to have him T-Razed immediately to see how we go forward.
Well, Judge,
Okay. Just. All I want you to do is not kill anyone, man. That's all I want, really. I'm not asking for much. You have, since day one in our court, have repeatedly refused to comply with bond conditions over and over and over. And I'm not doing a plea to where he can just get out and just do, and so you scare me.
So how do we resolve, Judge?
Huh?
So how do we resolve it?
So, yeah, I agree with you. I think that the correct thing to do would be probation but I would like to have him TRAS'd while he's in there. And I have a feeling I know what the TRAS is gonna say, and that's what I would like to do.
Okay. I would request you to set a bond.
Of course.
It's just costing him money, Judge. But it already is costing his family money.
So it's okay to just skip test?
No, it's not. It's a test, but I'm saying
It's a skip. I might just be asleep, but I'm not trying to skip me wrong. I swear to
stop,
God.
just stop talking. Yeah, you don't,
Sure.
just stop.
Okay, he goes, and it's literally, the minute he gets out, we have bond violations over and over and over. Now, what are we now, day what?
So, did the court want to be made aware of the presumptive results?
What did he test positive for?
THC, Suboxone, Oxy, and benzodiazepines.
He tested positive for OxyContin?
Yes, Judge, presumptively positive. It's being sent to the lab for the test.
What I had envisioned, what I think is probably do like a 2-year probation.
Right here, this is the turning point. The judge isn't confused. He's frustrated. 13 skipped alcohol tests. A GPS that mysteriously reconnects at 3:01 a.m. And positive tests for THC, Suboxone, and Oxy. Let me ask you something. At what point does non-compliance become a public safety issue? Because in DWI court, this isn't just paperwork. This is about preventing the next headline. And when a judge says,
I want to do like maybe 10 days as a condition, do an immediate TRAS. We'll get it done today, tomorrow, and we'll see what the TRAS says. And I'm going to go with what the TRAS says. If the TRAS says, and I promise you, Dustin, I will do what if the TRAS says that IOP, SOP is the proper course, then I'll do it.
Okay.
You know, but if they say residential, I think that's, I want to follow what the TRAS says because I think that's the proper one.
I don't think you take it. I just don't think you'll take it if it's residential.
Then I have a jury waiting right now.
You said the same thing. I mean, let's just see what it says. Let's try to get a quick TRS done.
For sure.
How quick are you?
So do you want to do the probation?
Yeah, he wants some probation. Judge.
Okay, let's do it.
My new kid.
Okay, Blaze, you let me know.
On this is.
Jones, probation.
Okay, yeah, I mean, we had offered the probation on first, so, yeah, it's TRS.
So,
Okay,
so probation,
2-year.
TRS conditions.
2-year.
Okay.
I want to do 10 days as a condition. That way I can get the TRAS done now immediately while he's in. And then I'm going to follow whatever the TRAS says. Are you Dad?
Yes,
How are you?
I'm fine.
Thank you so much for coming.
Can I say something?
First, go with Dustin first, because I don't want you to say something that really, just,
No.
please. Yeah, you guys can talk, and then later on, if it's, then,
Thank you, Judge.
thanks, Dustin. All right, come on up.
All right, so what we're gonna do, Judge, is he's not gonna bond out. We're gonna reset it for she said she'd get it to TRS in a couple days. I got him, he wants to see what the TRS is gonna say if he recommends DWI court, because that's kind of what he wants to do. Pretty much I think he'd be more successful in DWI court. So let's get the TRS done.
In sober court, he just wants to be out, so he doesn't have to be in custody, but the problem
this
is,
doesn't want to be in your court.
it won't be in my court.
I understand that.
So what-
TRS get that done, but he's not bonding out. Dad's not bonding him out. I told him he needs to sit and have TRS done, and they can get it done. So I'm gonna reset us. What, 5 days, Tuesday, and let TRS by then. He's not gonna bond out because they're not bonding out.
You want to talk?
Yeah, I don't want him on. I suggest I don't want.
I get it, I
You know
understand.
why.
I understand, I understand.
So, we'll do 5 reset for Tuesday next week, then they have TRS done by then.
Okay, all right,
Thank you, Judge.
yeah.
And I'll get the.
So we're not doing a plea today, but hold on. Dustin, come on up. I want you to know that if it says residential treatment
I understand.
and he's no, I mean, I'm setting this case for trial,
Absolutely
right? And I'm not gonna,
Are all full straight probation?
I understand.
Okay, cool. I heard it for.
No, he was asking.
No.
It's not legally possible.
my concern is that what I feel is gonna happen is when he does a TRAS, they're gonna say residential, and he's gonna say, I don't wanna do residential, I wanna be out. When we know based on here, it just doesn't work when he's out. He does what he wants to do.
If he
To
doesn't,
hell with the conditions.
if he doesn't want what the TRS recommends, then he'll take a jail sentence, and that's just what it is.
I'm not gonna take that. I'm not.
The judge isn't rushing to slam him with jail time. Instead, he's ordering a TSC evaluation. That's a treatment assessment. And this is a big deal, because instead of pure punishment, the court is saying, let's see what the professionals recommend. But here's the gamble. What happens if the evaluation recommends residential treatment and the defendant refuses? Are we watching someone fight for freedom or sabotage his last lifeline?
Facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 10th, 2025, officers were patrolling the area of the 13,500th block of Beechnut Street, Harris County, Texas. And they observed a white Hyundai Kona with an aluminum pole stuck to its hood due to a recent crash. A traffic stop.
What?
A aluminum pole stuck to its hood.
An aluminum pole stuck to the hood of a car.
Yes, Judge.
That's the basis for the stop.
Yes.
Okay.
This is word for word what when I observed a white Hyundai Kona with aluminum pole stuck to its hood, comma, recent crash. I then got behind the vehicle and yeah, finished. Yep.
Yeah, keep going, please.
Okay. I went back and got behind the vehicle. The officer started speaking with the defendant, who admitted to being driving and that he had crashed. The defendant told me that someone swerved into his lane and crashed into a pole. The defendant stated that he already called his record and that he was good to go. The defendant did not show any intentions of going back to the original scene and gave his information. While the officer was talking with the defendant, a security officer told the client that some people flagged him down the street, saying that the defendant crashed into multiple parked vehicles and drove off. The officer detained the defendant and went back to the original scene, which was a quarter mile from where the officer found the defendant.
Now that adds to it. I mean, that's certainly.
The officer spoke with a witness who stated that he was by the front of the apartment when he saw the white vehicle losing control, crash into a pole, and kept on driving while hitting another two vehicles. The witness stated that he was going around 60 to 70 miles per hour in a 35 mile per hour speed limit zone. This confirmed how the aluminum light pole got stuck to his hood. The witness stated that he did not see anybody else around the vehicle before the incident. The officer spoke with one of the owners of the vehicles that was struck, and she stated that it will be around $200 to fix her vehicle and wants to pursue charges. The complainant of the other pickup vehicle had damages to the back right part of that vehicle, and the complainant stated that the defendant crashed into her vehicle and left without providing information. The defendant left the scene without, okay. At this point, they called intake, and then they completed an inventory search of the defendant's vehicle and located a black backpack with 7.4 grams of marijuana, multiple clear plastic bags, and a scale.
Is he under arrest? I mean, if he's under
So
arrest,
they
then,
called,
but I didn't hear that he's under arrest or anything. They just up and go start searching?
they did say that the officer called DA intake and spoke with an EDA who accepted charges of the FSGI. And then it states there was an inventory search conducted.
Okay, so they did arrest him but what happened? Because is there an FSGI charge?
We're going to be honest, Your Honor, I'm not entirely sure what happened there. I'm working on it right now. If there's FSGI, right now I'm working on the complainants. We can get things worked out that way.
I mean, I don't
Right now, we do
understand.
not have an FSGI charge at this very second.
Did they accept it or did they not accept?
Based on the DIM statement, it says that we accept the charges. So I am trying to see why there's not a charge, but it's not something that we know.
What a weird.
The officer says charges were accepted for failure to stop and give information, yet only marijuana possession is filed. That's a red flag. Either there's a system glitch, missing paperwork, or intake confusion, and the judge catches it instantly. This is why probable cause hearings matter. Because if the paperwork doesn't line up, the case doesn't line up. Have you ever seen a courtroom moment where the judge seemed more confused than the lawyers? Welcome to Live Court.
Day so far.
Your Honor,
Can I say something? Your Honor?
No, don't. Now's not the time. I'm gonna give you a lawyer, and you can tell your side to the lawyer. But
I think it was a glitch in our internet system, so they could find marijuana, but they just, wherever, yeah, that's change.
is it going to go through? Do you know?
I need to look into our system, our changes, and figure out why it didn't talk into, if force comes to worse, we can make it a grand jury. But
So I'll give you, I guess, let's do this. I'm gonna appoint him a lawyer today, and I'm gonna find probable cause for the moment, but I wanna revisit it within the next couple of days to see what is going on. And then, all right, so I am gonna find probable cause for now, Mr. Reynolds. Can you look to see if he has a license, please?
Yes,
Driver's
Judge.
license. How old are you, Mr. Reynolds?
I'm 26, sir.
His driver's license is not eligible, Your Honor.
You're not allowed to drive. I don't care what's going on in your life. I don't care if you need groceries. I don't care if you need this, that. If you don't have a license and liability insurance, you're not allowed to drive. I will give you a lawyer today. You can say your side to the lawyer, but if you don't have a license and car insurance, you're not allowed to drive. Do you understand?
Yes, sir.
That is a condition of your bond. If I find that you do, I will revoke your bond, put you in jail, and no more PR bonds for you. So what I can have you do is I'm going to have Deputy Miranda give you an application. I'm going to have you fill it out. I'll have you talk to a lawyer today. But unless I guess let's do that. I'll have you talk to the lawyer and then we can revisit the situation after you talk to the lawyer. Please.
Thank you, sir.
Hi, Judge.
Hi, bud.
Approaching on Reynolds, I think, reapproaching on PC, I believe. He's over here on a possession of marijuana. She said you wanted to reapproach, so that's
Well,
it seems awfully fishy. I'm not sure why they detained him for FSGI. I do not understand that.
well, I think that there's a valid claim for an FSGI because someone says that there's a guy barreling through a neighborhood, hits a bunch of cars, takes off. We have someone that puts him there, right? That
Yes.
says it's him. My concern is that they say they accept charges for FSGI, right? But we only have a POM.
I understand.
I don't get it.
I understand. That makes no sense to me either.
So what I did was I found probable cause for now. I'm gonna give them another couple days to figure out what happened. Why, was it a glitch in the system?
Just for what it's worth, according to my client, he was on scene. He wasn't away from the scene. He was by his car when they were arrested him.
See us?
Way away from the accident.
Well, the accident happened and the car went forward and hit something. Anyway, it's okay. But
Show me-
But either he's FSGI and they can prove that he belonged to that marijuana, or they can't prove that he
So
belonged to that marijuana.
let's do this.
That's fair.
Why don't we set it for a formal probable cause?
That's fair.
Days, you pick it, I don't care.
Next week, okay?
Sure.
Okay, sure.
And then that gives them enough time to also look into
Gotcha.
what happened with the FSG, why is it not, you know?
Sounds fair.
In the interim though, come up.
Mr. Reynolds?
You tell me he doesn't have a license, right?
It is not eligible, Your Honor.
Like, I have here that he's Uber or something like this.
That's correct. That's my
You can't
understanding.
drive. You don't have a Texas driver license, right?
Come over here.
No. It's a yes.
Do you have a valid Texas driver's license?
Yes, as far as I was aware.
They're looking into the Texas.
I understand what
system
that just said,
because It's
sir.
not valid.
Right.
So you don't have a license.
I understand that now, sir.
You can't drive.
I understand that,
Don't
sir.
drive.
Yes, sir.
If I find that you drive, I'm gonna lose it. I'm telling you now, I will put you in. Because all I'm asking you to do is follow the law. I'm not asking much. If I find that you're driving, and I don't care what your excuse is, I don't care if it's a burning building and you have to say 50 kittens, I'm gonna lose it. You will be signing a promise with me. This is an affidavit that you're gonna promise me that you're not gonna drive. Do you understand? It can go really sideways if you do.
The defendant begged not to go to residential treatment, said probation would work, promised compliance, then picked up another felony DWI. This is the legal system's nightmare scenario. Someone who keeps driving impaired despite intervention. The judge isn't just talking about violations anymore. He's talking about death prevention. Hard question for you. At what point does the court stop asking and start ordering, because now the judge is making it clear?
What you need to do is contact DPS to figure out what you need to do to get your license back. I'll even give you the phone number. Let me stick these.
I already have that information.
Oh, there it is. I always
Yellow, you want blue? He's gonna give it to you. Just let him give it to you. Call me this afternoon and we'll figure out why it's not valid.
So this is the number to the driver's license division, the DPS. When you call them, call at 7 in the morning. Don't call at 9, at 2, at 1:53. You'll never get through. You have to call when the phone lines open up, give them the number and ask them why it's no good, and they'll tell you.
I need an SR22.
Oh, well, there you go.
I had
Then you know why.
I was just working at Uber every day, so I didn't know.
So you can't do that. Don't worry. You don't need to say anything else. So he's got to figure it out.
Look, Mr. Reynolds, do not drive. Do you understand?
Sort it out.
And you need car insurance before you drive too.
Oh, just, we'll fit. Okay. We're gonna be back next week, so we can answer like just next week. Or between next week, I'll answer them. All right,
Gotcha.
hopefully you can get that sorted out. Come back, I think says eligible, you'll be good to go. All right? Then he'll lift that restriction, I think is what he's saying.
Okay, come on up, Mr. Reynolds. We'll have you sign this and then you'll be free to go. Good morning, Mr. Ibarra.
Good morning, sir.
So you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, this is a under 21 UCW. I can still read you the facts if you would like. Okay. On March 3rd, 2025, an officer was dispatched to a shooting. The officer found the defendant in a back alleyway with a gunshot wound to his leg. The defendant had a mesh backpack in his possession at the time and was able to see that there was a black handgun inside. The caliber of the handgun matched shell casings located on the ground next to the defendant. The defendant stated that he shot the gun in self-defense at 3 black males who shot at him. Those suspects fled the scene after officers' arrival. The defendant was transported to Ben Taub Hospital, where the defendant was being treated for the gunshot wound to his left femur. The defendant admitted to being in the 114th Street Bounty Hunters gang and is 18 years old.
Okay, so was it really that, did he shoot himself or do we know that someone else shot?
We do not know. We know that the casings on scene match the caliber of the handgun that he had, but we don't know if he had shot himself and he stated he was being shot at by other people as well. So it's unclear.
So the only allegation is that he's underage, essentially. Okay. Mr. Ibarra, I'm going to find that there's no probable cause to go forward in your case. You need to be very careful. You get but one life. You know, God forbid something happens where you have a gun and you use it, and then you end up getting charged with something. You've gotten shot in the leg now. I mean, luckily it's not somewhere else. It could be life ending.
Sure.
When you hang with dogs or when you're bad places in the middle of the night, really, do something with your life. Get into school, graduate, get some knowledge.
Sure.
Take a seat.
I have Ms. Salmaron on the docket, Celia Salmaron.
How's she doing?
She did a T-RAS. It looks like they're recommending like the women's residential. Yeah.
Yeah, that's a good idea.
So the issue, Judge, she needs to be on a probation. She has 2 open PCSs currently.
No rush. Really. That's probably the appropriate thing.
Okay, so her felony court date is March 28th. And the problem is that I just, so she has the old PCS, but she has a new one. And, you know, she's not going to be able to bond out. The felony court did give her bonds, but she's not going to be able to afford those.
What are you asking for?
When a judge enters a protective order in a family violence case, especially involving a pregnant complainant, the stakes change completely. This isn't just about punishment anymore. It's about prevention, and notice how specific the judge is: 200 feet. No weapons. No harassment maybe, because violations of protective orders are taken extremely seriously. One slip up and bond disappears. This is the court drawing a very hard boundary.
A trial date. My problem is, Judge, it could take months and months for them to get the lab back on the PCS. Or I can get a
Do they
reason.
have the last back? I mean, how long?
I'm sorry, I didn't catch.
Salmoron.
Okay, okay.
Yeah, it's an old case, Colin, you're right. I didn't realize it's from May of last year.
It does appear that the labs are still pending.
Yeah, is it really gonna take that long to get? I mean, how long do you think it'll take? Do we have any, are the labs back on the first case?
Yes, Judge, I think they are, because I think they're in connection with this DWI.
Have you eval'd? Are you ready?
I'm ready. I mean, I was ready before she forfeited, so.
The labs are back on the second case.
It's the same case as our case. Yeah, I have no idea how long it takes to get labs back. You don't know?
No idea.
We have an offer in there. It's an old case. We can set it for trial today if that's what you want to do, Judge.
It's not me, it's Connor. I'll do whatever you want. It doesn't matter to me. If you want to set it, I'm fine. If you want a little bit more time, I'm fine with that too.
Yeah,
You tell me, you're in the driver's seat.
I think that, so she has court next Friday. If we could get just a couple week reset, see what happens next Friday, see if they get the labs, and then if not, then we can.
And, perhaps have her see how long it'll take.
Yeah, and I'm gonna
Ask someone else.
I'm gonna reach out to her felony attorney and then maybe the prosecutor, see if we can't work out something.
Global?
Yeah.
That or ask them, hey, how long does it take? If it takes 6 months to get a lab back, I mean, that's unreasonable.
Yeah.
I'm with you at that point. So
For the time being, I'll put an eval to do it for us.
For sure.
Next setting, maybe.
yeah,
Sounds good. Thank you, Judge.
for sure. Morning, Mr. Eli. Come on up. How are you? I know you don't want to go into treatment tonight, right? And I acquiesced to you last time. You asked me, please, I can get it done. Please don't let me do it. Don't put me in residential. Don't. And I listened. And what happened? No. Yeah, you caught a felony DWI, not. We put you on probation. A month and a half later, you pick up a felony DWI. So all this, acting. So now, if this doesn't show that residential is the right thing, then I don't know what does. The only thing that we're trying to do is prevent death on our roads. That's the only thing, right? And somehow we have to get through these. Every other way that we've tried just doesn't work. This is the only other thing that we have left at our disposal. So if you want, we can just set it for a hearing. And if they prove to us that you have violated your probation, then we're going to amend your conditions to put you in residential treatment. We can do this any number of ways. We can have a full-blown hearing, or you can just sign the conditions. But if they prove it to me, that's what's going to happen.
I'm not signing the conditions.
Okay, so set it for a hearing, and then get the probation officer here, and then we'll see. And then they prove to me that you have violated your probation, then I'm going to amend your conditions. I'm not letting you go. Ever. Do you understand? I'm going to keep you until we get this straightened out, one way or the other. Okay? Understand? Okay, good. So I'm at your mercy when you want to set it. You want to do a week, we can set it in a week and then just have a hearing. It's just at the mercy of the probation officer, whatever they are.
The defendant literally told officers that if released, he would assault the complainant again. That statement alone can dramatically affect bond decisions. And then the immigration warning. That's not random. In Harris County, immigration detainers can absolutely change the trajectory of a case. Jail isn't just jail anymore. It can mean months in federal custody. The judge is essentially saying, you get one life. Stop escalating it. But here's the bigger question.
Best way. Okay? Good morning, Mr. McCann.
Morning, sir.
So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Okay.
Complainant and defendant are in a former dating relationship. On 6/29, officers were dispatched to a disturbance at a business in Harris County, Texas. Complainant entered the business, and when she exited and walked back to her truck, she observed the defendant there. Complainant believed defendant had followed her. Complainant said that defendant was intoxicated and started to insult her. Complainant stated defendant struck her on the left side of her face with a closed fist as she sat down inside of her truck, causing pain. Complainant stated she went after defendant as he entered his truck and grabbed his shirt. Complainant stated she was momentarily dragged as she held onto the defendant's vehicle.
So it was a hit to the face, you said?
Yes, Judge. We have not been able to arrest her yet. I will let you know that I was reading through the offense report. I don't know if this was mentioned to intake, but in the offense report, it does look like she was 4 months pregnant at the time, and the defendant was aware, so this baby refiled as a felony. I'm not sure yet, but it's where we're at right now.
Mr. Tejada, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to consume alcohol, illegal drugs, unprescribed controlled medication. If I find that you're using, I will revoke your bond, put you in jail. I'm going to do everything in my power to protect my public at all costs. Do you understand?
Yes, sir.
You are not to have any contact with the complaining witness in this case, not to be in possession of weapons, and I'm now entering what's called a magistrate order for emergency protection. This is a court order that identifies Ms. Lopez Leiva as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Sir.
If you violate this court order, the state can and will probably file a violation of protective order, and that is the capital murder of misdemeanors. It is one of the worst cases you can pick up, a violation of protective order. Do you understand?
Sir.
You pick up one of those, violate conditions, I can have a hearing to hold you at no bond, zero bond, and I'll do it in a heartbeat to protect my county. Any prior assaults against this person or?
No, Judge, this looks like it was the first one.
Okay. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Parham. If he tells me he can't get a hold of you because you've gone AWOL, I will issue a warrant for your arrest. You pick up a new case, I will issue a warrant for arrest. You get no more PR bonds. Do you understand?
Yes, sir.
You will be randomly called upon to go take drug and alcohol tests. If you fail to go, then likewise a warrant for your arrest will be issued. I'll have you go sign a reset with Victoria. You'll sign the order for protection here. You'll get with Felicia for your bond conditions, and after that, you're free to go.
Just,
Oh, is there no bond set?
well, no,
there is.
bond said, Judge, with regards to the bond condition, I was wondering if we could, amend those or have them reflect the no threat and harassing communication, instead of no contact.
They haven't been able to reach her.
They haven't, but the DA hasn't, but then she has spoke with her back. And she had spoken to the back and told her that she would want to proceed with the case. She would,
I don't know. I mean, if she's 4 months pregnant,
no, she's already had the child. They already have a child now. That's the only reason why I say now.
Yeah,
Because
this did happen back in June.
they do have a
If,
child.
let's do this. I want to know, I mean, if that VAC was done, that VAC was done in 2024. I don't know anything recent. So until I know what she wants now, then, and if you could, facilitate, perhaps give a phone number, maybe that's something that can happen now. I don't know, but I like to follow the wishes of the complaining witness, and I don't know what her wishes are. If she doesn't want contact with you, then I'm going to worry. If she does, then we can revisit that at that time. But understand, for this instant, no means no. It doesn't mean maybe. It doesn't mean I got to go get my kid. It doesn't mean someone has to go take the SAT. No means no. Do you understand?
Sir.
Okay. All right. Thanks, guys.
This way.
Good morning, Mr. DePaz.
Good morning.
So you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, sir.
Oh, thank you.
On March 10th, 2025, at approximately 12:18